Hello friends, in the series on the income tax cases, today we will discuss the case of Commissioner of Income Tax versus Industrial Development Bank of India Limited. This case has been reported in 454 ITR at page number 811. The matter has been decided by Supreme Court and the date of the judgment is 26th April 2023. This case is regarding section 263. Section 263 talks about of the revision of the order prejudicial to the revenue. According to me, section 263 is there on the statute because the department cannot go against the order of the assessing officer into appeal. That is why section 263 is there, because the department can revise the order of the assessing officer subject to two conditions which has to be fulfilled cumulatively. First is that the order should be erroneous, and the second is that the order should be prejudicial to the interest to the revenue. The facts of the case are very interesting. This is a perfect case which throws light on the appetite of the department for the litigation and how the department moves for the assessment and reassessment and revision in case of assessee, and how casually the department takes its duties. In this case, the order of the assessee was done under section 143 subsection 3 and some additions were made. After that, the department realized that some incomes have still escaped income. That is why the assessment under section 147 read with section 148 was done and some additions were again made. Here also the department was not satisfied and the Commissioner of Income Tax issued the notice for revision under section 263 on the issues which were part of the assessment order under section 143 subsection 3. But when this revision notice was sent, it was not as per the limitation period of 2 years if the date is to be seen from the original assessment order. The date was picked from the date of the reassessment order, but the issues were picked from the assessment order of section 143 subsection 3. It was the point of the assessee that if you are going to revise the order or if you are going to revise the subject which was the part of the assessment order under section 143 subsection 3, so in that case the limitation is to be seen from the date of the order under section 143 subsection 3. When the matter was before the Honorable Bombay High Court, the Bombay High Court quashed the revision by saying that the limitation was starting from the original assessment order, and if we see that date, then that revision was out of limitation. The High Court didn't accept the contention of the department that the limitation period is to be seen from the date of the reassessment order, because the point of revision was not from the order of section 147 but it was from the order of section 143 subsection 3. As usual, the department filed the appeal against the order of the Bombay High Court, and when the matter was before the Supreme Court, the Supreme Court said that the order passed by the High Court does not need any interference, and in this case the revision which was done under section 263 is not valid and it is barred by limitation. When there are two assessment orders, one is section 143 subsection 3 and the other is section 147, and if the department wants to revise the order, then the subject matter of the order and the limitation period should be parallel. You cannot take the approach that you are picking up the point of revision from section 143 subsection 3 order and you are picking the date of limitation from the date of the order under section 147 read with section 148. Friends, this case is very important because this case is the height of litigation on the part of the department, because the department takes very casually the assessment of the assessee, because they have various powers under the various sections and they reopen assessment, they do the revision, but still that should be according to the law. At the end of this case. Once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus Industrial Development Bank of India Limited. This case has been reported in 454 ITR at page number 811 and the matter has been decided by Supreme Court. The date of the judgment is 26th April 2023. Thank you, friends.